So back at the end of July, I posted a video about an interesting case coming out of the federal court in Massachusetts between Keurig, the coffee manufacturer, and SharkNinja, where one of Keurig's former executives, Brad Wilson, left and on his way out the door allegedly took a bunch of proprietary material with him, and then Keurig sued, trying to freeze them in their tracks and saying, hey, he can't just take those materials with him. It gives SharkNinja an unfair advantage to compete against us in our space. Now, about a month and a half later, SharkNinja has filed its opposition papers to that initial application of Keurig, and they raise two interesting points. One is they point out in their papers that the non-compete that was supposedly entered into between Wilson and Keurig was unenforceable as a matter of Massachusetts law because it didn't contain a garden leave provision, which is a clause requiring employers to pay executives or employees that are signing a restrictive covenant, a non-compete, extra compensation in exchange for agreeing to that non-compete. But the more important thing I wanted to discuss with you is the second issue that they raise, which is that in their view, nowhere in the complaint does Keurig identify any specific trade secret that Wilson or SharkNinja supposedly availed themselves of. And in that regard, both federal and Massachusetts law with respect to trade secrets say that it's very clear that a court can't accurately decide the question of whether a trade secret exists without first understanding precisely what it is that's being asserted is secret. So that raises an interesting issue, because if it turns out, after the smoke clears in this case, that Keurig didn't have the goods to back up their claim that trade secrets were actually misappropriated, they do face the prospect or the possibility that the court could say that they brought the claim not in good faith or in bad faith, in which case, theoretically, Keurig could be on the hook for the defendant's attorney's fees incurred in defending this action. That's just something to file away in the back of your mind as a practice tip if you're considering bringing a defend trade secrets action or anything of that sort. Thanks for listening and hope you have a great rest of the day.